officers. And in this session today, we're going to discuss treatment in a similar manner as the state, or TAS as a simpler format. So we're going to kick us off. I'm going to start and go over the application process for the TAS, and this is specifically for Clean Water Act Water Quality Standards, Section 303, and Section 401, which is the water quality certification process. And then I'll hand it over to my colleague, Russ. He's going to discuss the new implementation rule that about a year ago, it came into effect in November, the Clean Water Act, Section 401A2. And then I also have my colleague from ORC, from Office of Regional Counsel, Desean Garnett, and he'll go into more of a deeper dive. So sort of like the history of TAS and any special cases. So we have a full view for you, a little bit of everything. So I will kick us off with the application process. Jump. If you can do the next slide, please. There we go. Okay, so the pathway for today, our roadmap is basically what I just said right now. I'm going to do an overview of treatment in a similar manner as the state, as TAS. What is TAS? What programs are eligible? And what are the requirements? And then we'll go into the 401A2, 401, the new 401 regulations, and then the history of TAS. Okay, so for TAS or FAE, many of you probably have TAS for your Clean Water Act 106 and your Clean Water Act 319. So that's more on the financial assistance side. And then there's also TAS for the regulatory. So today, as I said, we're speaking about Clean Water Act Section 401 and 303, which is the water quality standards. And also, as you can see on your left side, there's all the regulatory programs. Each one requires a specific TAS. We think it would be easy in one beautiful world if you apply for one TAS for all programs, but that's not the case. You have to apply for TAS for each of these programs. And as I mentioned, you probably already have the FAE, so you've kind of have gone through a TAS process for your 106 and your 319 program. Okay, and this screenshot is just to kind of give you an idea of the TAS approvals. Specifically for the Clean Water Act Section 303, the water quality standards. Nationwide, there's 84 tribal nations that have the TAS, and specifically in Region 9, we have 31. And I believe there's, out of the 31 that have TAS, there's 11 approved EPA water quality standards for those tribes. Because once you have TAS, which is your program authorization, then you move on to developing your water quality standards, and you work with the water quality standards folks for that. Oops, I think I jumped one. The TAS decision process, so for the last, I would say 4 or 5 years, our section has been very busy in working. So you would start off working with your Clean Water Act 106 project officer. If you're interested in TAS, is having that conversation. So I highly recommend having that discussion. Why are you interested in TAS? How do you go about it? And you can also maybe talk to some of our attorneys as well if you have any legal questions. So starting with a draft application, I would highly encourage that first. And then after that, you would do an official submission. So it's a cover letter to our regional administrator with your application. Once you submit the official application, then there's an administrative process that we go through. We receive your application, make sure that it's complete, all the information is in there. EPA would provide notice. So this is a public comment period. So we usually do a public notification in the local newspaper near your tribal nation. And this is for the public to comment. And the only thing the public can comment on is the jurisdiction, the reservation area of your application. That is for 30 days. And also if your tribal nation is near another contiguous tribe, then we under our EPA policy, we do offer tribal consultation at the same time that we're doing the public notice. If there's any comments that are received during that public period, we do meet with the tribe that has submitted the TAS application. We review those comments and we notify and we share them. If there's no comments, then obviously nothing to share. And then we go on to EPA's review, which is an internal process. So we internally work with our assigned attorney. And then after that, then we also work with headquarters team. There's a review in headquarters that they review the application after the EPA region does. And then towards the end, we are working on the decision document, which is the final decision document for your TAS. And that is the last step. And then after that is what? Celebration time, because you have your TAS. Yes, woo! You have your TAS, and then it's presented by a regional administrator, either at an RTARC or most likely at an annual conference. So that's sort of like the simplified process. And it varies from time to time, depending on when you have that conversation. It could be between 1 and 2 years. Some applications are more complicated than others. Thank you. These are the steps as to what needs to be included in your TAS application. The first one is federally recognized. Your tribe needs to be federally recognized. And how do you do that? Basically by submitting your tribal nation highlighted in the federally recognized tribal list. One, checked off, you're done. That's your federal recognition. Number 2 is your governing body. Basically a statement that describes your tribal government, your chairperson, tribal council, and we can work with you on that as well as how it needs to be descriptive. Working with your legal counsel as well in that area. Number 3, I would say, is the most important, where we ask for maps that you want to include as part of your TAS, your jurisdiction, the boundaries of your reservation, all the lands within the reservation, all the surface waters, you want to include that as part of the TAS. Some reservations have parcels outside the formal reservation that we call informal. So those are trust lands, parcel lands that are outside. Sometimes those are included as part of the TAS application as well. So that's the most important key, to make sure we have that. If we review it and we feel like it's not a clear map, it's not, the boundaries don't seem clear, then we need to go back and forth with you to make sure we have that map before we send it on for review as well. Number 4 is functional capacity, basically the environmental programs that you have. Who is going to administer your water quality certification program? Because you're applying for the program authorization for 401. So who is going to be responsible for that? Normally it's the environmental department, environmental director. If there's no one on staff for that position at hand, you can state in the application that there is going to be a hiring for that person to monitor the water quality certifications. And then in the 5th process is more, again, just clarification. If we feel as project officers within your application, we need additional documentation, then that is the time where we would go back and forth with you to ask to make sure we have a complete application, because we're here to help you. Our goal is for you to have your program authorization for 303 and 401. Okay, next, I'm going to have Russ come up and give us more description on the new 401 implementation rule.
Thank you, Loretta. Yeah, so there's a couple of important changes that came out in the 2003 water quality certification rule that I just want to bring to your attention that have to do with treatment as a state. Let's see, is it this? Oops. So treatment as a state, basically, Section 401 of the Water Quality Act is what we call water quality certification. So any federal license or permit that results in a discharge into waters of the United States requires a certification from a state or a tribe with 401 jurisdiction to certify that that activity will comply with their water quality requirements. And historically, prior to the 2023 rule, if you wanted to assume 401 authority as a tribe, you also then needed to develop eventually EPA-approved water quality standards. Now, under the new rule, there's two new provisions to get TAS for 401. You can become a TAS certifying authority without needing to develop EPA-approved water quality standards, as long as you have some kind of water quality requirements that are developed by your tribal organization. So tribal policies, tribal laws, ordinances that relate to protecting your water quality, you can certify based on those certifications. So you no longer need to have EPA-approved water quality standards to have authority to issue water quality certifications as TAS. So that's one of the new things that we have here. So there's a nuance in the language. So the term used is water quality requirements. So it's not standards that are EPA approved. So anything that you have that's water quality related. The next thing that's really important is what's known as the 401A2 provision. And this is what's known as the neighboring jurisdiction. So the responsibility of when the Congress wrote the Clean Water Act, they said, okay, well, a jurisdiction is going to certify that it's going to comply with their water quality requirements. What about the downstream or the neighboring jurisdiction? And that's where 401A2 comes in. And again, prior to the 2003 Clean Water Rule, you had to have treatment as a state for 401 to be considered a neighboring jurisdiction. The new rule allows tribes to get treatment as a state just for 401A2. So this is a process that will bring the tribe in as a neighboring jurisdiction. You don't need to do 401 certifications, but you can get treatment as a state to be treated as a neighboring jurisdiction, which means, say hypothetically, you have a tribal lands in California, the state regional water board issues a water quality certification for an activity that's going to happen, say, a mile upstream of your jurisdiction. If you have treatment as a state for 401A2, EPA then evaluates that activity, what the nature of the activity is, if it's going to affect or potentially may affect your water quality, which then brings you to the table. And you have an opportunity then to engage with the federal agency who's issuing that permit and decide whether or not it will affect your water quality and if additional permit requirements need to be made to make sure that your water quality is protected. So the 401A2 process, even if you don't want to have the resources to take on a whole certification program, the 401A2 is a way of just ensuring that that gets you a seat at the table when these certifications are issuing for projects and activities and discharges specifically that affect water quality. So just some things to be aware of, that there's some new opportunities under the new water quality rule for treatment as a state. So that would be for whatever so Loretta was talking about whatever you submit your maps for the jurisdiction. So whatever you submit for jurisdiction for treatment as a state under the 401A2 provision would be what would be covered under that. So it's really kind of up to you to decide what you include in your application for that as far as what lands would be covered.
All right. Thanks, Russ. Thanks, Loretta. You know, it's always tough being the last presentation of the day because I know people are tired and want to go home, but thank you for sticking with us. So I'm going to go to the next slide. One more. All right, there we go. So I'm going to go over regulatory TAS. This is, different than the financial TAS under Clean Water Act sections 106 and 319. This is about the regulatory program. So this is setting, real requirements on regulated entities within the reservation. And I'll specifically focus on Clean Water Act 303. So TAS has been, at the forefront of what EPA has been doing since its inception. Starting in 1984, EPA developed one of the first ever Indian policies in the federal government, and it's really a description of how EPA interacts with tribe on matters that affects tribes, like environmental matters that affects tribes and tribal members on the reservation. And specifically, it sets forth some expectations about how EPA needs to be transparent with tribes in regards to these matters. And from there, Congress, developed federal environmental statutes, directed EPA to enforce those statutes, and as part of those environmental statutes, included provisions that allows not only states but tribes the authority to implement the provisions of the statutes, because EPA can't do it all alone. They can't implement every single federal environmental statute. The states and tribes, have a hand in ensuring that they tailor the unique environmental requirements to their residents. And so it's important that these statutes do include provisions for tribal authority to implement environmental law. And within those statutes, the Congress has directed EPA to effectuate the provisions of the statutes, meaning that EPA has to develop its own regulations to afford tribes treatment in a similar manner as the state under the statutes. And there's different processes within the different federal environmental statutes, so it makes it somewhat difficult to keep track of the different requirements, but they all kind of follow the same theme, especially from what I see in the Office of Regional Counsel, ensuring that the tribes have the appropriate legal authority to implement whatever federal environmental statutes at hand. And then from there in 2008, EPA developed a TAS strategy. This details how EPA will process treatment in similar manner as the state applications, and just gives details about how EPA will be transparent with the tribe about the processing of the application and what the tribe needs to do if it has questions about the status of the application, and then also lets the tribes know that if EPA needs to request more information in the application, that it will do so to ensure timely review. And then there's the tribal consultation policy, which is somewhat relevant for TAS, but it just sets forth expectations for government-to-government consultation between EPA leadership and tribal leadership, making sure that everyone's on the same page in matters affecting tribal members and concerns in the environment. And then I'll get into the reinterpretation rule later in this presentation. Next slide. So the question is, should a tribe apply for regulatory TAS? So the answer is, it depends. It depends on how comfortable the tribe feels with developing its own environmental programs and assuming regulatory responsibility from EPA to implement those programs. We know that environmental programs are costly. They require, a great deal of financial resources. They're not money makers. EPA is not making money for the federal government, neither states or tribes. And so these are costly things. So the tribes have to determine whether or not they have the financial resources now and whether they have the adequate personnel to implement the programs, especially in areas that are new for the tribes. And it really depends too on what resources are on the reservation too. So say for example, there's not a lot of sources emitting air pollutants, then it might not make sense to apply for TAS under the Clean Air Act. But if there's a ton of water resources that need protection, then it would make sense for a tribe to consider seeking TAS under the Clean Water Act programs. Next slide. So this goes into the different TAS programs under the Clean Water Act, and a separate TAS application is needed for each of the programs. Unfortunately, and like Loretta said, you can't have one that covers them all. They all have unique requirements, all specific, different skill sets for an employee who's working on these matters, who's implementing these statutes. So one of the huge ones is in regards to point source discharges. So this would be TAS under Section 402 of the Clean Water Act, which would be the MPDS program. And ultimately, this would give the tribe authority to issue permits to dischargers to ensure that any discharge complies with the Clean Water Act, or otherwise the discharger wouldn't be able to discharge pollutants into the covered waters. We received recently one application for TAS for the MPDS program. It was the first in the country too. So in my office, we're helping to process that application and working through the unique legal issues that have come up. So it's really exciting to work on something so cutting edge. And then, relevant to this discussion, there's a 303 program for water quality standards. This is just TAS for the program, which means that the tribe would be seeking eligibility to develop their own water quality standards. And it doesn't mean that the tribe is approved for the standards quite yet. It just means that they're eligible to apply for submission of standards to EPA for review. And then there's a non-point source program, which covers the TMDL program and the state implementation programs. You know, TMDL's issues like stormwater runoff and construction site runoff. And then there's section 401 certification, which Russ was just talking about. So that, you know, that gives the tribe another opportunity to apply for TAS and apply for, or have more authority on the reservation to ensure that any discharges comply with the Clean Water Act and don't degrade water quality within the reservation. Next slide. So what does it mean for the tribe to receive TAS for water quality standards? Like I said, it means to administer, to apply to administer the program, but it doesn't actually grant authority to implement any of the water quality standards yet. That's a separate application that, you know, requires EPA review and approval by a different program. So the TAS program is handled by the tribal clean water section in the water division, and then the actual standards themselves are by the drinking water program. So they're different groups within EPA that review these standards. I work with both of them, and it's exciting to see like the evolution of application going from TAS to the actual development of standards themselves. And then it does mean that there will be some workload issues. You know, the Clean Water Act requires triennial review of water quality standards every 3 years. So that would mean that if the tribe wanted to seek TAS for water quality standards and eventually get approved for those standards, it requires a workload issue of reviewing the standards every 3 years, make sure that they're current and protective of all water resources on the reservation. And then another thing to mention, if there are conflicts between tribal standards and state standards, then those need to be resolved by the EPA regional administrator. So that could be a significant issue and one to consider if there are significant state water resources that intersect the reservation. All right, next slide. So what does the TAS for 303 not do? It does not expand the tribe's existing jurisdiction, so it doesn't grant the tribe any more rights than it does outside of the Clean Water Act 303 program, meaning that the tribe wouldn't be able to use TAS as a basis to enhance rules against fishing or expand water rights. It doesn't deal with groundwater at all, and it doesn't expand the scope of what waters would be considered waters of the United States on the reservation. It's really just the eligibility to apply for the standards themselves. Next slide. And so some of the special issues I deal with for TAS applications are define the reservation, like what does it mean for the tribe to apply for eligibility to implement or, you know, apply to implement water quality standards within the reservation. It's not always clear cut, like what lands included in reservation and not. And the easiest determination is determining what the formal reservation is. This is usually spelled out in treaties, executive orders, statutes. And so attorneys that we work with for tribes, they give us evidence of what is considered the tribe's formal reservation. And oftentimes the tribe will acquire new land after the establishment of the formal reservation, and we need to consider whether or not that should be included within the reservation. And it would be if the land would be taken into a trust by the BIA, or it's allotment land, or what we consider a dependent Indian community. So we just need evidence to assure that the land is, you know, considered Indian country under our statutes that we use. And so if it is, the land that's newly acquired outside the formal reservation is treated just like the formal reservation. We call that the informal reservation, but there's no difference in terms of TAS about how those lands are viewed. So next slide. Another issue that we deal with a lot is inherent sovereignty, and this is the tribe's ability or authority to regulate non-member conduct within the reservation, specifically on lands that are privately owned, so land that's not owned by the tribe, but owned by non-members of the tribe. And there's this concept of inherent authority, it's like another word for tribal sovereignty, saying that, you know, tribes have all the rights that Congress didn't specifically limit. And this concept applies when there's no congressional delegation for TAS. So it's really relevant for the Safe Drinking Water Act, which you don't deal with a lot in my section, but it's not as relevant for the Clean Water Act programs or the Clean Air Act because there is a congressional delegation under those statutes. I don't know why there's not one for the Safe Drinking Water Act. Maybe it was an oversight, but it is often harder for tribes to assert TAS under the Safe Drinking Water Act because of the lack of a congressional delegation. And so when there is no congressional delegation, in order to determine whether or not a tribe has TAS for non-members on non-member-owned fee land, we apply a test from the Supreme Court in Montana versus the United States. This was an issue involving the Crow Nation in Montana and their decision to limit hunting and fishing rights by non-members on their reservation. And this person took the case of the Supreme Court. Supreme Court ruled in that private individual's favor and said that there's this presumption that tribes cannot regulate the conduct of non-members on non-member-owned fee land within the borders of the reservation unless the conduct threatens or has some effect on the political, economic, security, or health and welfare of the tribe, or the non-member has a consensual relationship with the tribe through commercial dealings, contract leases, or other arrangements. So in the context of EPA, oftentimes we see that what's most relevant for a potential person's activity that may affect the tribe would be on the first part of the test, where it threatens the political integrity, economic security, or health or welfare of the tribe, meaning that this person's activity may have cause some issues, may increase environmental pollution within the reservation or degrade water quality. So it could be a reason why the tribe needs to regulate this non-member's conduct, which we'd have to apply the Montana test, make findings, and then eventually that decision could be challenged by that individual who's being subject to regulation by the tribe. But oftentimes we try to resolve those issues by working with the private individual and the tribe, see if they could come to some agreement about whether or not the tribe should be a certain regulatory jurisdiction over that non-member. Next slide. So I was saying previously, the Clean Water Act and Clean Air Act contain delegations, express delegations from Congress, saying Congress says that tribes have the authority to regulate non-member conduct, so it's not an issue. We don't need to apply the Montana test. It's straightforward under these statutes, which I enjoy, but I also do enjoy the legal analysis that comes with the Safe Drinking Water Act too, especially when the tribe has a good case for showing that they should regulate non-member conduct. So I had some citations for these delegations, but yeah, if you're interested in I can supply those. But it's very clear what Congress intended, that there is no issue about whether or not tribes can regulate the conduct of non-members under these statutes. Next slide. We could skip these next two just because I feel like I've already covered most of the special issues that I deal with in my work, and we had another attorney that was going to present on some different special issues, but he's not here today. We could skip this one too. And I think I already explained the concept that sometimes a tribe will acquire new land, which will expand the limits of the reservation. So that means that the tribe needs to apply for TAS over the newly acquired parcels. And if they don't, their TAS decision will be limited only to the portion of the reservation that they received approval for. All right, next slide. So where can I find more information? There's some useful references within the statute about the reinterpretation rule, the TAS strategy protocol, some of the TAS regs in the Clean Air Act, and there's more in the Clean Water Act and Safe Drinking Water Act. Okay, next slide. And then this is a save the date for EPA Region 9 2025 Tribal Clean Water Act workshop happening May 19th to the 23rd, 2025. Laura, do you want to provide more information?
Yeah, so this was towards the end of our presentation, but just wanted to put a plug out that this is Clean Water Act workshop is coming up next year. It's been a while since the last one, so just want to make sure you take a note. Scan the QR code. It's going to be in reference of the Clean Water Act 106, the Water Quality Monitoring Program, and Clean Water Act 319. There's also going to be field activities. So take a note, and we just want to make sure we hopefully see you in May, and it's going to be in Fallon, Nevada. So I also wanted just to go back to, as I was describing the process for the Clean Water Act TAS application, if you have the Clean Water Act 106 program, you can place this in your work plan. If you're thinking about it, you can talk, like I said, to your Clean Water Act project officer if it's this year or next year or the next couple of years. So this is something that can be funded with your 106. And I think that was all of our presentation. So if you have any questions. Yes.
Thank you. Thank you, Zach Jagone with Shingle Springs Rancheria. So I'd like to follow up on Crystal's earlier question about the 401A2. So if that is allowed beyond the boundaries of trust land, does that include like all fee land or the tribe's historical territory, or what are the requirements for where that's allowed to be used?
So, yeah, so typically it would be within, it would include, obviously, any of the lands that would be in the traditional tribal reservation. And then as Desean was saying, there's these other sort of types of tribal allotment lands and things like that. So it's really sort of up to, so it would need to be lands that sort of would fall within some of those categories, either traditional reservation lands, fee lands, or allotment lands. So whatever you submit as part of the application, say we want tasks for these areas for 401A2, that would be, and then assuming that's, that process submitted, it would be those lands that would be sort of directly under your tribal jurisdiction. So that's what it would cover. So if you were, say, in California, if California was a certifying authority, you would then be the neighboring jurisdiction anytime the state of California issues a certification. EPA would then do an analysis to figure out whether that would affect your water quality. So that it would include it's sort of up to you what you submit to include, but it would be limited to sort of those types of lands, if that makes sense.
Okay, awesome. Thank you. And that was like specifically referring to when you say fee lands, like fee lands within the boundaries of a reservation, like Desean talked about with the Montana case and everything?
Exactly. Yes.
Okay.
Yep.
Thank you.
Mm-hmm.
Yeah, so just a clarifying question, because when you say reservation, what we deal with in California is we don't have reservations. Some of us have rancherias, right? And so when our tribe, in particular Shingle Springs, has purchased land that is not adjacent to the original rancheria, but for example is 45, 50 miles away on the river, because that's considered ancestral territory and is ancestral territory from where the tribe was removed from. In the event the tribe acquires property and it is not yet in trust, but it is what we call fee land, does that allow us to apply for TAS? Because then that has major implications for us and the ways that water management decisions along those riverways are impacting the tribe. Does that make more sense? Is that more clear?
Yeah. I think so. In those instances, we wouldn't be able to deem the tribe eligible for TAS for the newly acquired land until it's taken to a trust by the BIA.
Okay, perfect. Thank you.
Thank you. One more thing on that. So if the parcel in question is in process of being transferred into trust and there's an active application with the BIA, but it's non-contiguous with the reservation, does that allow us to qualify for TAS?
It might, but we'd probably want to wait until the land is taken to a trust formally before you'd make a decision on the TAS. Because if it's pending, then to us it's still in fee land, and we won't be able to make a decision on that parcel of land.
And earlier you said allotment land would make us eligible. So how does that work exactly?
Yeah, so tribal allotment is considered Indian country under the statute that we use to determine whether or not a piece of property is within the boundaries of the reservation. It's under 18 USC 1151. It's the United States Criminal Code. The environmental statutes, they don't have their own definition of Indian country, so we use the one that's already embedded in federal law. And included in the definition of Indian country is Indian allotments. So we do consider that those allotments taken to trust for members would be considered Indian country.
Thank you.
Yep, same application. So yeah, a land could be either tribal trust, Indian allotment, or dependent Indian community. To us, we'd consider it all Indian country.
I have a pretty basic question, so forgive me if this has already been covered or everybody but me in the room understands it. But as far as I'm just trying to understand the 401 A2, right? The neighboring jurisdiction. Just so I've wrapped my head around it correctly, if I could throw out a hypothetical situation, if the tribe that employs me is granted TAS, and there is the reservation is constrained to like a mile on either side of the river. So hypothetically, if say Caltrans wants to build a bridge upriver of the reservation, that could have implications on water quality within the reservation and tribal fishing rights, then whatever entity that's going to issue them permits to do that work has to consult with the tribe first, right?
So what happens under the 401A2 process? So let's say that under that hypothetical, and you made a comment to Caltrans or to, let's say, the Army Corps of Engineers who was issuing the permit for the bridge. It's, hey, we have concerns about this project. Then what happens is under the 401A2 process, EPA then makes, what we do is we consider a lot of factors. One of the factors we consider is if we are aware that a neighboring jurisdiction is concerned, we then make what's called a may affect determination. Once we make a may affect determination, and then as the 401A2 neighboring jurisdiction, the ball kind of goes into your court. And then you can then look at that project activity. You can look at the permit requirements of the federal agency. You can look at the water quality certification that was issued by the state and determine whether or not that project potentially will affect your water quality requirements. And then if you do make that will affect determination, then what the federal agency has to do is they then have to have a public hearing. They have to hear out your concerns. There's also informal consultation that can happen. It doesn't necessarily have to go to a public meeting, but if that can be one of the options. But yeah, the 401A2 process, if you make a will affect, gets you basically that additional consultation with the federal agency to determine what additional things might need to be, what additional conditions to that permit would need to be in place to ensure that your water quality is protected. So what it does is it gives you kind of more of an elevated seat at the table than just saying, replying to like a public comment or something like that, because you actually have the opportunity to make a will affect, and then the agency has to consider, that will affect determination and what may be necessary to protect your water quality.
Great. Thank you for the clarification. I appreciate it.
Absolutely.
Thank you, everyone. I don't see any additional questions. We'll be up here if you have any other ones.
Hello. Just an announcement. Karaoke is tonight with the costume contest in the main ballroom at 6 o'clock. Hope to see y'all there.